Good afternoon, dear students. We continue our lectures on the course Diplomacy and Consular Law. Our today's lecture will be devoted to such topic as law of special missions, diplomatic law of international organizations. During the lecture, we will talk about such issues as: first, legal status and functions of special missions. Second, privileges and immunities of special missions. Third, permanent mission of a state to an international governmental organization. And fourth, privileges and immunities of permanent missions. So let's start from the first question, legal status and functions of special missions. It was considered desirable to lay down rules for ad hoc missions, which are now called special missions. After years of preparations by the International Law Commission, the United Nations General Assembly adopted the Convention on Special Missions on the 8th of December 1969. The Convention has been in force since 1985. According to Article 1, letter A of the Convention, a special mission is a temporary mission representing the state which is sent by one state to another state with the consent of the latter for the purpose of dealing with it on specific questions or of performing in relation to it a specific task. This definition clarifies that special missions are regular instruments of bilateral diplomacy. This definition also contains a number of elements: the temporary character of the mission, which distinguishes it from the permanent diplomatic mission, the fact that it represents the sending state, and the fact that it is sent for the purposes of dealing with the receiving state on specific questions or of performing in relation to it a specific task. Above all, Article 1 makes it clear that a special mission may only be sent with the consent of the receiving state, consent that is to the sending of the special mission as such. Article 2 specifies that consent means prior consent and that it must be given through the diplomatic or other agreed or mutually acceptable channel. Article 3 makes yet further provision for consent by providing that the functions of a special mission shall be determined by the mutual consent of the sending and the receiving state. Ad hoc diplomacy is the oldest form of diplomacy. As the United Nations Secretariat explained in 1963, the custom of sending a special envoy on mission from one state to another in order to mark the dignity or importance of a particular occasion is probably the oldest of all means by which diplomatic relations may be conducted. It was only with the emergence of national states on a modern pattern that permanently accredited diplomatic missions, entrusted with a full range of powers, came to take the place of temporary ambassadors sent specially from one sovereign to another. However, also the legal rules which were evolved to determine diplomatic relations between states were therefore based largely on the conduct of permanent missions, so that special missions came to seem merely a particular variant of the other. The sending of special missions was never discontinued. During the 18th and 19th centuries, such missions were frequently dispatched in order to provide suitable state representation at major ceremonial occasions such as coronation or royal weddings, or for the purposes of important political negotiations, particularly those held at international congresses. In submitting its final draft on diplomatic intercourse and immunities to the General Assembly in 1958, the International Law Commission stated that although the draft dealt only with permanent diplomatic missions, diplomatic relations also assumed other forms that might be placed under the heading of ad hoc diplomacy, covering itinerant envoys, diplomatic conferences, and special missions sent to a state for limited purposes. Since diplomacy is based on mutual consent, the sending and receiving state must agree that a special mission will be sent and which issues will be dealt with. A temporary mission may be sent to focus on a single issue or may have a broader agenda. During a visit of a foreign minister, many bilateral and international issues will be on the agenda. That both parties are free to agree on the function of a special mission flows from the principle of the mutuality of diplomatic relations. Article 3 of the Convention on Special Missions only repeats the obvious. According to Article 3, the functions of a special mission shall be determined by the mutual consent of the sending and the receiving state. The Convention contains no other provision defining the functions of special missions. There is no provision corresponding to Article 3 of the Vienna Convention on Diplomatic Relations or to Article 5 of the Vienna Convention on Consular Relations. It was suggested during the negotiations that the normal task which special mission will perform is a task that would ordinarily be performed by a permanent diplomatic mission of the sending state. Permanent diplomatic missions have a wide range of functions and are by no means limited to what may be thought of as classical diplomacy. In any event, there was no agreement during the negotiations to limit the functions that might be performed by a special mission. Some states considered that special missions might concern technical matters as well as political ones. The key lies in the requirement of mutual consent on the functions of the mission. Two or more states may each send a special mission at the same time to another state in order to deal together with questions of common interest. Again, the emphasis is on the consent. Article 18 provides that special missions from two or more states may meet in the territory of a third state, but only after obtaining the express consent of that state. Provision is made for the various categories of members of special missions. The sending state may freely appoint the members of the special mission, but their details must be given to the receiving state prior to their appointment, and that state may object to the overall size of the mission or to individual persons. Detailed provision is made for notifications to the Ministry of Foreign Affairs of the receiving state. All official business is to be conducted with or through the Ministry of Foreign Affairs of the receiving state or with such other organ of the receiving state as may be agreed. The provisions of the Convention on Special Missions follow those of the Vienna Convention on Diplomatic Relations, with requisite changes for the special mission's temporary character. The head of a special mission does not need an agreement. The sending state must inform the receiving state about the names and designations of the members of the delegation. The receiving state may decline to accept the size of a mission or a specific person as member of the mission. It can also declare a member of a special mission persona non grata. However, this provision is not of much practical importance. The scale of facilities, privileges, and immunities provided for in the Convention. It is Article from 22 to 49. Follows with only relatively minor modifications that provided in relation to permanent diplomatic missions by the Vienna Convention on Diplomatic Relations. This includes, most importantly, inviolability of the person and immunity from criminal jurisdiction of members of special missions. It also includes immunity from civil and administrative jurisdiction, subject to the same exceptions as members of a permanent diplomatic mission, plus an additional exception for an action for damages arising out of an accident caused by a vehicle used outside the official functions of the person concerned. So, members of special missions enjoy the same inviolability as diplomats. They are free from a coercive power of the receiving state and enjoy its protection. Their premises, archives, and documents are inviolable, and they enjoy freedom of communication and freedom of movement. Among the other differences between the privileges and immunities accorded under the Convention on Special Missions and the Vienna Convention on Diplomatic Relations are the following. Tax exemptions for the premises of the special missions applies only to the extent compatible with the nature and duration of the functions performed by the special mission. The head of mission's consent to enter the premises of the mission may be presumed in case of fire or other disaster that seriously endangers public safety, and it has not been possible to obtain his or her express consent. And archives and documents should, when necessary, bear visible external marks of identification. Article 21 provides that the head of the sending state, when he or she leads a special mission, enjoys the facilities, privileges, and immunities accorded by international law to heads of state on an official visit, and further that the head of government, minister for foreign affairs, and other persons of high rank, when they take part in a special mission, enjoy, in addition to what is granted by the Convention, the facilities, privileges, and immunities accorded by international law. The Convention on Special Missions has not become popular. At this time, only 39 states are a party to the Convention. Most of the larger states, like the United States, Russia, India, Japan, and the larger West European countries, with the exception of Spain, are missing from the list of participants. For them, the Convention on Special Missions is unnecessary. They arrange visits of special missions and their agenda through the normal diplomatic channels. Rules like those contained in the Convention are seldom, if ever, discussed. Both sides start from the assumption that the host country, with the two states' common goal in view, will treat the guest with respect. Questions of privileges and immunities come up only if something goes wrong. This happened when an Iranian government official, the former deputy prime minister Dr. Tabatabai, was taken into custody by German authorities when he arrived in Germany in 1981 because opium was found in his luggage. Before his departure, he had informed the German ambassador in Tehran that he was making a business visit to Germany. At the end of January 1981, the Iranian government confirmed in writing that Dr. Tabatabai had been sent as the official envoy to conduct political negotiations in Europe. The German Foreign Office was of the view that Tabatabai therefore enjoyed immunity from German jurisdiction. It took various court decisions until the immunity of Dr. Tabatabai was finally recognized. For smaller countries, the situation is different. Since they do not have embassies in many countries, they may choose to maintain diplomatic relations with those states where they are not permanently represented by sending special missions. They feel that their ad hoc envoys should be treated like resident diplomats. Since only a small number of states have joined the Convention on Special Missions, and since its rules have not become customary in international law, the cases when a country can invoke the rules for special missions are limited. If a country attaches great importance to these rules, it can try to fix them in a bilateral agreement with the receiving state before the visit takes place. The Convention on Special Missions is the applicable international law as between the parties thereto. Yet it is not clear how it is applied in practice even between the parties. In any event, the parties are relatively few and there are few other treaties on the subject. So as between most states and in most circumstances, the governing rules on special missions and other official visitors are to be found in customary international law. It is difficult not to share Sinclair's assessment when he said, "This effort at progressive development and codification has accordingly been only partially successful, no doubt because of the reluctance of governments to accord a wide range of privileges and immunities to special missions and their members when, in the view of governments concerned, the grant of such privileges and immunities was not justified by functional reasons." While the elaboration of the Convention within the International Law Commission and in the Sixth Committee of the General Assembly has no doubt influenced the rules of customary international law in the field, there is no reason to suppose that all or even most of its provisions are reflected in customary law given the circumstances of its adoption and the lack of the support for the Convention among states. Although some uncertainties remain as to the precise scope of special mission immunities under customary international law, it is generally accepted that customary international law requires mutual consent and representation of the sending state and the grant of personal inviolability and immunity from criminal jurisdiction for the duration of the special mission and during a reasonable period of time for travel. But it would seem that the rules of customary international law are both wider and narrower than the provisions of the Special Missions Convention. They are wider in that the class of official visitors who may be entitled to immunity is wider than that foreseen in the Convention. They are narrower in that the range of privileges and immunities is more limited, being essentially confined to immunity from criminal jurisdiction and inviolability of the person. Special mission may consist of foreign ministers, special envoys, and it could be a governmental delegation. Fostering relations with other countries is a foreign minister's business. Personal contacts with other countries are considered necessary. Therefore, the foreign ministers are among the most frequent travelers among high government officials of any country. When foreign ministers travel abroad, they wish to present their views on political developments to foreign leaders, to listen to the views of their partners, to sound out possibilities for cooperation, to ask for support of their own foreign policy initiatives, or to agree on joint actions. Bilateral visits include negotiations by the foreign ministers only occasionally. When foreign ministers, however, participate in sessions of international conferences or organizations, negotiations are regularly included. Foreign ministers also use their trips to formulate foreign policy. Just as the visits by heads of government, the activities of foreign ministers abroad are a mix of policy making and diplomacy, with the emphasis on diplomacy. Foreign ministers are interested that their visits are reported by their country's media or, if possible, by TV. Presidents of many states have increasingly used special envoys for a multitude of missions. For example, they represent the president at important ceremonies such as a coronation or a funeral. They act as goodwill emissaries, convey presidential letters, collect information for the president, or negotiate or mediate with foreign governments on the president's behalf. Henry Kissinger, the national security advisor of the United States President Nixon, became a well-known special envoy. At the end of 1973 and the beginning of 1974, for example, he traveled between Washington, Jerusalem, and various Arab capitals to mediate the Middle East conflict. Governmental delegations are sent abroad to deal with special subjects. Sometimes they have the task of discussing issues of common concern with the representatives of the host country, for example, political cooperation. In other cases, delegations are appointed to negotiate a treaty. Treaty negotiations are important and numerous. Thousands of international treaties link the members of the community of nations. Additional treaties will be concluded. The subjects of these treaties can be political, such as arms limitation, atomic energy, or defense. Other subjects are of an economic nature, such as civil aviation, economic cooperation, and development assistance. Bilateral negotiations concern also cultural relations and consular issues, such as extradition, juridical assistance, and narcotic drugs. Many delegations are meeting in the framework of regular consultation that were earlier agreed upon. These meetings can be those between the heads of state or government, between foreign ministers, between other ministers, or between experts. The visit of the head of state, the head of government, the foreign minister, other ministers or other leading personalities is a highlight in an embassy's life. It is at the same time a challenge for the embassy. The visit, for example, of the foreign minister needs a lot of preparations. After the date for the visit of the foreign minister has been agreed upon, the details of the agenda and the program are discussed between the embassy and the Ministry of Foreign Affairs in the country that the minister will visit. The embassy entrusts the preparations to one or more diplomats. In the Ministry of Foreign Affairs, several departments are responsible for the preparations, particularly the Protocol Division and the regional desk responsible for relations to the visitor's country. The agenda is easily agreed upon. Regularly, each side accepts the suggestion of the other side. The agenda is dominated by current bilateral, regional, and global problems. The program often includes a meeting with the head of state or head of government. Sometimes the head of state decorates the visitor. The visiting foreign minister may also see other ministers, for example, the Minister of Trade, pay a visit to the President of Parliament, see the chairman and members of the parliamentary groups. Sometimes a foreign minister gives a speech during his visit. In that case, the embassy's advice is welcome with regard to finding a host and an audience. To include meetings with oppositional forces and human rights groups is a problem in some countries. It can be helpful to call these meetings private ones. Luncheons, receptions, and dinners accompany the visits. It is up to the embassy to suggest a guest list if the foreign minister is to host a social function. Whether a supporting program, for example, the visit of other cities than the capital, the visit of cultural monuments and artistic performances is planned, depends on the time the visitor spends in the host country and his familiarity with that country. The visitor's foreign ministry prefers to negotiate the details of the program through its embassy in the host country. The foreign ministry of the host country, however, arranges the program also through its embassy in the visitor's country. Therefore, it is important to see to it that the two tracks run parallel. The embassy is also involved in the preparations of the substance of the talks. The Foreign Office asks the embassy to prepare papers concerning bilateral issues. This demand gives the embassy the chance to include those items into the program that the embassy considers important or unsolved. The regional desk in the foreign ministry at home reviews these papers and includes them, together with all those papers prepared by the various divisions of the foreign ministry or by other ministries, in the minister's folder for the visit. The ambassador accompanies the visitor during his visit. There are visitors who hesitate to take their ambassadors along to the meetings. The ambassador, however, can be the visitor's best advisor because he knows the country and the minister's interlocutors. The ambassador and one or several members of his staff are members of the minister's delegation. They also serve as note-takers. The diplomats use the minister's visit to renew contacts and to make new ones. Sometimes, under the umbrella of their highest superior, they succeed in solving problems which they faced for quite some time. The members of the embassy staff take care of the delegation. A delegation office is set up either in the embassy or in the minister's hotel. Ministers feel that the political success depends on the reporting by the media at home and in the host country. Therefore, the embassy takes care that the journalists from home and from the host country receive the necessary information. A press office is set up to take care of the journalists from home and facilitates their work. In case the minister wants to give a press briefing, the necessary facilities must be available. Embassies are needed for the preparation and realization of visits by political leaders. The quality of the preparation often decides whether the meeting will be successful or not. Therefore, it is in the best interest of a political leader to make use of the familiarity of his embassy staff with the host country. The local knowledge of the embassy is also useful during the visit because it helps to avoid unnecessary tensions. And now let's talk about permanent mission of a state to an international governmental organization. As you know, permanent missions are the agencies that are sent by member states to an international governmental organization. The agencies representing non-member states are typically called permanent observer missions. In the second half of the 20th century, international governmental organizations and consequently permanent missions proliferated. States maintain permanent missions at the seats of the United Nations, some of its specialized agencies, and the UN bodies in New York, Geneva, and Vienna. They have sent permanent missions to the United Nations Educational, Scientific, and Cultural Organization and the Organization for Economic Cooperation and Development in Paris and to the Food and Agriculture Organization in Rome. Brussels is the host to permanent missions to the European Union and the North Atlantic Treaty Organization. Permanent missions in Strasbourg represent states to the Council of Europe. In Vienna, states maintain permanent missions to the Organization on Security and Cooperation in Europe. The members of the Organization of American States have established permanent missions in Washington, D.C. The United Nations convened a conference in Vienna in 1975 to lay down the rules for the relationship between states and international governmental organizations. Rules regarding the status, privileges, and immunities of permanent missions were to be included. During the conference, the conflict between the sending states that tried to accord a high level of privileges and immunities and the host countries that wished to have their rights protected could not be breached. The Convention on the Representation of States in their relations with international organizations of the universal character of 1975, passed by the majority of the sending states, has not been ratified by the host states and has not entered into force. But its provisions are, however, useful as far as they indicate general practices of states. The various headquarters agreements provide rules for permanent missions. For the establishment of a permanent mission of a member state, neither the consent of the international governmental organization nor of the host state is necessary. In 1948, the United Nations encouraged member states to establish permanent missions to the organization. Article 5 of the Convention states that member states may, if the rules of the organization so permit, establish permanent missions for the performance of the functions mentioned in Article 6. The tasks performed by a permanent mission to an IGO differ from those carried out by a diplomatic mission to a state. A permanent mission of a state to an international governmental organization has in general two functions, as Article 6 of the Convention indicates. It represents the sending state to the organization and it provides the participation of that state within the organization. Representing the sending country to the organization means maintaining contacts to the organization, negotiating with the organization, and protecting the sending country's interests towards the organization. The partner for these activities of a permanent mission is the organization's organ that takes care of the common interests of the organization, that is, the Secretariat. In this respect, the duties of a permanent mission resemble the activities of a bilateral mission. For example, the permanent mission wants to discuss its government's policies and tries to win the Secretariat's support or to make it drop or change its plans. The discussion can, for example, focus on the budget of the organization or on the item on that session's agenda. A permanent mission may announce a special financial contribution to a project that the Secretariat is charged to implement. The talks can center, for instance, on the requirement and recruiting of the sending country's citizens or on providing documentation. The more important task that a permanent mission performs is to provide the sending country's participation within the organization. The members of the permanent mission fill their country's seats within the organs that take care of the national interests of member states. The members of the permanent missions to the United Nations, for example, are sent to the General Assembly, the Security Council, the Economic and Social Council, and to many committees. The members of permanent missions to the European Union represent their countries, for example, in the Committee of the Permanent Representatives, that is COREPER. Members of permanent missions advance the policies of their governments worldwide in countless plenary, committee, working and contact group meetings. It is the task of permanent missions to be up to date on events. In this respect, the members of permanent missions perform the usual diplomatic functions. They gather information and report it back home. They proceed according to the instructions they receive. Permanent missions will often have an influence on decision making when the issues under discussion are complex and negotiations are changing course. Then they suggest to their ministries at home how to adapt to the changes. Their main task, however, is to negotiate in an almost unending series of meetings. The focus of their work is diplomacy. They agree to compromises but try at the same time to uphold the basic policy decisions of their governments. Since the discussion of a topic may take weeks, months, or even years, the position of the participants needs to be adjusted many times. Permanent missions have to arrange their positions in continuous dialogues with their governments and the representatives of the other countries participating in the meeting. If any form of diplomacy deserves to be called modern, it is the multilateral diplomacy within an international governmental organization. Since many foreign ministers attend the general debate of the annual UN General Assembly, these meetings provide a welcome opportunity for regular bilateral diplomacy. Many foreign ministers have a tight schedule of meetings with their colleagues. These meetings have to be prepared by permanent missions. The United Nations can also offer a convenient platform for bilateral talks between states which have not exchanged diplomatic missions, either because they do not recognize each other or because they found it unnecessary, though they recognize each other diplomatically. The Federal Republic of Germany used the United Nations for talks with Eastern European countries in the middle of the 60s, when it had only exchanged trade missions but not yet embassies with their countries and with these countries. So now let's talk about the staff of a permanent missions. Permanent missions to international governmental organizations are headed by permanent representatives. They have regularly the rank of an ambassador. The position of the ambassador to the United Nations, the European Union, or NATO belongs to those of the highest rank in many foreign services and is filled with experienced diplomats. Some countries, however, have appointed politicians or other prominent personalities to head some of their permanent missions. An agreement is not issued for an ambassador who is sent to an international governmental organization. The organization has to accept whoever is sent by a member state. The host state has no right to accept or reject an appointee since the ambassador is accredited to an independent legal personality. Credentials, however, are also useful in relations between states and intergovernmental organizations because they make clear that credit may be given to all the newly appointed permanent representative may say in the name of his government. Heads of missions to the United Nations present credentials to the Secretary General, those accredited to a specialized agency to the Director General. Permanent missions need staff members. Missions to an organization that deal with diverse issues need a large staff. The members of a permanent mission include, like those of embassies and consulates, three different categories. They have diplomats, an administrative and technical staff, and a service staff. Diplomats are those who perform the functions to represent the member state to the organization and who provide the participation of their state within the organization. The members of the administrative and technical staff work as secretaries, registrars, finance, security, or communication officers. They are usually home-based employees and alternate during their careers between embassies, consulates, and permanent missions. Permanent missions need also drivers, gardeners, craftsmen, and cleaners. These members of the service staff are typically local employees. Many intergovernmental organizations have periodical general meetings. The United Nations General Assembly, for example, meets annually. These meetings are attended by the heads of state or government, foreign ministers, other ministers, or high-ranking dignitaries. The high-ranking visitors are advised by officials and experts, including members of the permanent mission, whose knowledge and experience within the organization is needed. Altogether, these officials form a delegation, called by Article 1, Paragraph 1, Number 10 of the Convention of 1975, a delegation to an organ. Delegations coordinate their activities in delegation meetings. The basic positions of their governments are, however, usually laid down by instructions from capitals that are binding for delegations. The size of a permanent mission to an IGO is determined by the sending state. Article 14 of the Convention of 1975 restricts the size of a mission to what is reasonable and normal. Since the Convention has not yet entered into force, the restriction is only valid if it has been accepted in practice. This assumption, however, is doubtful. Host states feel that the restriction doesn't go far enough because it enables them only to exert indirect pressure and doesn't give them a tool to force a mission to downsize its staff. There is no uniform standard for the privileges and immunities of permanent missions and their members. The Convention of 1975 has not entered into force, and even if it did so, it would establish rules only for universal organizations and the missions accredited to them. If one is looking for the privileges and immunities of a permanent mission to a specific IGO, one has to consult the operative agreements for that organization and the practice of the host state. Therefore, one has to check the same treaties that laid down the privileges and immunities for the organization. Privileges and immunities for diplomatic missions flow from the Convention on Diplomatic Relations. There is, however, no general international instrument with regard to the privileges and immunities for international governmental organizations. Privileges and immunities of an IGO are based on international treaties in force for that particular organization. Since there are many different organizations, many different treaties exist that lay down the privileges and immunities of IGOs. Matters are even more complicated. Since only the territorial state can restrict its own authority in favor of an IGO residing therein, the cooperation of the territorial state is indispensable. Various patterns have been chosen to establish privileges and immunities for IGOs. For example, the privileges and immunities of the United Nations are based on the three-stage pattern. Article 105, Paragraph 1 of the UN Charter stipulates that the United Nations shall enjoy in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purpose. This provision obliges each United Nations member state to grant the principal and subsidiary organs of the UN privileges and immunities. The details of the privileges and immunities that have to be granted are laid down in the Convention on the Privileges and Immunities of the United Nations of 1946, also referred to as General Convention. This convention was supplemented by headquarters agreements with those countries where the United Nations has its seat and offices. The United Nations concluded a headquarters agreement with the United States in 1947, with Switzerland in 1946, and with Austria in 1967 and 1979. The United States and Austria are bound by the General Convention, but Switzerland is not a party to the Convention. When other United Nations bodies were created, the same pattern was used. For example, when it was decided that Nairobi would be the seat of the United Nations Environment Programme, a headquarters agreement was concluded between the United Nations and Kenya in 1975. This agreement refers to the General Convention. Also, the headquarters agreement concluded in 1994 between the United Nations and the Netherlands concerning the International Court of Justice that has its seat at The Hague follows that pattern. It declares the General Convention applicable and provides for supplementary regulations. The specialized agencies of the UN are not included among the beneficiaries of Article 105, paragraph 1 of the UN Charter. Many of the constitutive treaties of specialized agencies have, however, similar provisions. Article 40, paragraph 1 of the Constitution of the International Labour Organization, for example, shares the wording with Article 105, paragraph 1 of the UN Charter. The privileges and immunities of the specialized agencies are based on the Convention on the Privileges and Immunities of the Specialized Agencies of 1947. A review of the various treaties reveals that IGOs, member states, and host countries have taken different approaches to accord privileges and immunities to permanent missions and their members. The members of the permanent missions to the United Nations in New York are well protected. Section 15 of the UN Headquarters Agreement with the United States of America of 1947 states that the United States accords to members of permanent missions and their staff the same privileges and immunities subject to corresponding conditions and obligations as it accords to diplomatic envoys accredited to it. The reference to corresponding conditions and obligations means, among other things, that the United States as host country can declare a member of a permanent mission persona non grata. This interpretation is confirmed by Section 13, letter B, of the United Nations United States Headquarters Agreement, stating that diplomats shall not be required to leave the United States otherwise than in accordance with the customary procedures applicable to diplomatic envoys accredited to the United States. In a number of cases, the United States administration has made use of this possibility and expelled members of permanent mission to the United Nations. The status of the permanent missions in Geneva is similar to that of the missions in New York, but has a different legal basis. The agreement between Switzerland and the United Nations of 1946 contains the same restricted privileges and immunities that are mentioned in the General Convention. Switzerland, however, accords diplomatic status to the permanent missions and their members by analogy to the international conventions. A headquarters agreement concluded between Switzerland and the World Trade Organization in 1995 declares explicitly the privileges and immunities of the Vienna Convention on Diplomatic Relations applicable. This agreement goes even further than the Vienna Convention on Diplomatic Relations by granting an exemption from the value-added tax and by confirming that the Swiss government will facilitate entry, residence, and exit of the members of permanent missions. Convention on the Privileges and Immunities of the United Nations of 1946 and the Convention concerning Specialized Agencies of 1947 take a more restricted approach towards granting privileges and immunities. The pattern of this convention is repeated by various headquarters agreements. These treaties do not mention permanent missions, but refer to representatives of members to sessions of organs. Since these duties are also performed by members of permanent missions, the provisions of these treaties are applicable to these members. According to these international treaties, representatives of member states do not enjoy comprehensive inviolability, but only immunity from arrest or detention and from legal process with regard to official acts. They are granted inviolability of documents and freedom of communications. Since representatives of member states have to transit the host country, it was important to exempt them from immigration restrictions and from baggage inspection. Finally, the treaties contain a vague reference to the privileges and immunities that are enjoyed by diplomats. They are declared applicable for representatives of member states as far as they are not inconsistent with the previously mentioned restrictive provisions. Section 14 of the General Convention makes it clear that the functional approach is the conceptual basis for granting privileges and immunities to members of permanent missions. It states that these exemptions are not granted for the personal benefit of the individuals themselves, but in order to safeguard the independent exercise of their functions. The Convention draws the consequence that a state is obliged to waive the immunity of an individual if the immunity would impede the course of justice. This obligation can, however, not be enforced. These restricted privileges and immunities are only applicable if there is no basis for a full diplomatic status. And the last thing I would like to mention today, it is the missions of non-member states. Many IGOs invite or accept representatives of non-member states. In the practice of the United Nations family and the Council of Europe, for example, these representatives are called permanent observers, and therefore it is a permanent observer mission to international governmental organization. Other IGOs, for example the European Union, do not use this term. Representations of non-member states are called missions or delegations. Different international governmental organizations have developed different rules on how to deal with representatives of third countries. The Council of Europe, for example, has developed strict rules concerning observers. Observer status may be granted to a state willing to accept the principles of democracy, the rule of law, and of the enjoyment by all persons within its jurisdiction of human rights and fundamental freedoms. Observer status was granted to Canada, the Holy See, Japan, Mexico, and the United States. States that enjoy observer status may appoint a permanent observer to the Council of Europe. A third country mission represents the sending country to the organization. It can perform the usual bilateral functions, such as maintaining contacts with the organization, negotiating and concluding agreements with the organization, and reporting on the organization's activities. A permanent mission of a non-member state cannot take part in the formal decision-making of the organization. It does not have voting rights. Whether and to what degree it can influence the decisions of the organization depends on the rules of the organization for observers as well as on the political weight of the mission's home state. Some IGOs have generous rules for observers. Observers to the Council of Europe are allowed to attend committee meetings. Observers invited to the United Nations are allowed to address the General Assembly. The permanent observer missions of the states to the United Nations attend the meetings of the Security Council, the General Assembly, and the main committees. Since decisions are prepared by various groups, access to these groups is important for observer missions if they wish to have an impact on preparing decisions that are important for them. Thus, an observer mission can do lobbying and perform political functions within the IGO. The regulation in force for a specific international governmental organizations sometimes determines the privileges and immunities for a third country mission. Such provisions stipulate that missions of third countries accredited to the organization should be accorded the customary immunities and privileges by member states in whose territory the organization has its seat. The customary immunities and privileges are also in this case to be understood as reference to the rules of the Vienna Convention on Diplomatic Relations. If operational agreements do not contain provisions regarding privileges and immunities of observer missions, host states can grant them. So this was the main information concerning the topic of our lectures. Thank you for your attention.